Okay, there we go. So tonight, we will be talking about the topic for week 5, which is about judicial powers, particularly about the separation of judicial and non-judicial powers. And this topic is important because it has actually been the subject of a lot of cases in the High Court. And it also pretty much takes up a lot of the topics in the legal memorandum assessment. So it will be quite helpful for you to really try to immerse yourself in trying to understand this topic. And if you happen to have any questions, then this will be a good time to raise them. So tonight, in terms of the key outcomes, after studying this topic, you should be able to identify, distinguish, and explain judicial and non-judicial powers. I'd like to say hello to the little girl there with Marianne. Explain the separation of Commonwealth judicial and non-judicial powers, and then cite and discuss key judicial decisions that elaborate on the notions of judicial and non-judicial powers and the separation of Commonwealth and non-judicial powers. Now, before we continue with the discussion questions, perhaps some of you might have a question, and I'd be happy to try to answer them. Would anyone have a question? Questions, anyone?
Oh,
yes, Marianne.
I'm up to week 4. I just finished week 4 in lecture.
I think I might have to use, hang on, Marianne. I might have to use a headphone because the speaker is too good. Oh, hang on. Okay, good. That's better. Yes.
Can you hear me?
I could.
You can't hear me? Oh, okay. Sorry. Doesn't matter.
Okay, go on. Yes.
Can you hear me now? Yeah.
I could.
I thought we were going to do week 4 tonight, so please don't target me because I haven't done week 5.
I think we did that last week.
Oh, sorry, I haven't got the tutorial. Is the tutorial on yet?
We had the tutorial for week 4 last week. So we're doing the tutorial to cover the week 5 topic.
Oh, okay. So did you upload the tutorial?
Oh, yeah. So the problem was when we had the tutorial last week, I was holding it from the Brisbane campus because there was an open day, and I had to be there to assist in the open day. The problem was Zoom automatically records the tutorial into the hard disk or the hard drive of the computer, and I didn't realize that. I was trying to save it, but I couldn't save it, so I need to go back to the campus in order to have access to that file. And so on my end, I don't have the recording right now, but I'll try to go back on Monday next week.
Okay, cool. Thank you so much. Bye.
Yep. Okay.
Excuse me, Manjo, I have a question.
Who would
Sorry.
that? Yes. Who's that?
Jessica.
Jessica. Yes. Go ahead.
Hello. So I've just been going through your notes for this week. On page 6 of the lecture notes, you make reference from the Boilermakers Doctrine that states a non-judicial power can be validly vested in a non-Chapter 3 court or tribunal. Now, this might seem like a dumb question, but it took me a while to kind of understand what that means. But for me, what the non-judicial power I had trouble understanding, which will come into further detail later in this lecture, I know.
Yes.
But would we look at a non-judicial power as like the three different, like the executive, parliament, and judiciary? So non-judicial power will be anything that's like the executive and legislative way of looking at it, rather than the judicial. Does that make sense?
Yes, actually it makes sense. So
I just don't quite understand, I don't understand a standard definition for non-judicial. I can't wrap my head around it.
That's right. So a simple way of looking at a non-judicial power is that it is not a judicial power. So you have 3 kinds of powers under the Constitution or in the framework of our government. You either have the executive, you have the legislative, or you have the judicial power. So if it is a non-judicial power, it can only mean that it's either a legislative or an executive power. So that's one way of looking at it.
Okay, yeah.
In a very simplistic way. So the crucial point really, and that's what we're trying to do tonight, is to really determine when a power is actually a judicial power and when it's not. Because if the power that is being exercised is judicial, then it can, especially at the level of Commonwealth courts, it can only be exercised by Chapter 3 courts or federal courts if it is a judicial power. Now, if it is a non-judicial power, we will observe later on that it's actually possible for judges of Chapter 3 courts to exercise non-judicial powers in their personal capacity following the persona designata doctrine on the assumption that it is with the personal consent of the federal judge, and at the same time that the exercise of non-judicial powers of these federal judges in their personal capacity would not be incompatible with their functions as judicial officers, which means that they need to be independent, and which means that it must be shown that their integrity will not be compromised or that their impartiality will not be compromised. Because if there is an indication that their integrity or their independence will be compromised, then that will not be tolerated by the High Court, mainly because it will bring the judiciary into disrepute when the judiciary is crucial, primarily because in Australia, we only have a partial separation of powers. So therefore, it is important that the judiciary must make sure that it remains its full independence from both the executive and the legislature.
Okay, so does that mean, like, if you have a judge who's part of the federal, so the Commonwealth, like, so the way I see it is a judge of Australia, basically. And then
that's too broad. You mean, is it a federal judge or a state judge?
Yeah, like a federal judge. Is that what you mean? Like when you?
Yeah, because I mean, a state judge is still a judge of Australia. He's just a judge.
Yeah. Oh, okay.
So you mean a Commonwealth judge?
Yeah. Oh, sorry. What was your question?
So when you speak of a judge, it will not be helpful for you to describe that judge as an Australian judge, because he might be a state judge, in which case he is an Australian judge. So it will be better to distinguish between a federal judge as opposed to a state judge.
Right. Okay. All right.
Refer to what? A state judge or a federal judge? So when you speak of
a federal judge, sorry.
You're actually saying that the judge belongs to a Chapter 3 court.
Yes. Okay. Yeah. So the federal judge is like the circuit court, federal circuit court, family court. Is that right?
That's right. Yes.
And there's okay. So if that federal judge gets presented with the case that's like a non-Chapter 3 court within Queensland, can is that what you're
there was something I missed there. Can you repeat that part? So if that federal judge is presented with a case, what do you mean by that?
So if you have a federal judge who does like, that's what I quite don't understand, is that if a federal judge, can he still exercise his powers as basically as a state judge type role? No?
If you're
I'm probably really confusing everything.
Yeah. So, okay, let's be clear. So in Australia, that's fine. So in Australia, we have the Commonwealth as opposed to the states. So when you speak of the Commonwealth, we're speaking of the federal system. And so therefore, if we're speaking of courts, we're speaking of the federal courts or Chapter 3 courts. So these are courts which are constituted under Chapter 3 of the Constitution. Now, there are a distinct set of judges, and these are the state judges. So the state judges are not judges that belong to Chapter 3 courts because they're judges of the state. And so therefore, if a judge is a state judge, he would belong to a state court and not a federal, that is a Chapter 3 court. Now, if your question was, would it be possible for a federal judge to at the same time be a state judge, the answer will have to be no. Mainly because if a judge is a federal judge, it will likely mean that the appointment of that federal judge will have to be according to Chapter 3 of the Constitution. So there is a requirement as to the manner by which federal judges are appointed. It has to be according to Chapter 3 of the Constitution, which means it has to be by the Governor General in Council. And it also means that there is a requirement as to remuneration of the judge, of the federal judge, which means it cannot be changed, for example. And it also means that a federal judge can only be removed according to what is in the Constitution, which, for example, is about dishonesty. On the other hand, if you speak of a state judge, the appointment of a state judge is not according to the Chapter 3 of the Constitution. It is according to whatever law is passed by a state. And which means, therefore, for example, you can even have a state judge who is not a lawyer. You can have a state judge who could be appointed only for a period of, let's say, 3 years. Now, that is not permissible in Chapter 3 courts, because judges under the Constitution can remain as federal judges up to the age of 70. And they cannot have a fixed term, because the Constitution requires that they remain in office unless they're removed according to the Constitution. They must remain in office up to the age of 70. A state judge, on the other hand, can have a fixed term of even, say, 1 year or even 2 years. He can be removed according to whatever legislation or whatever the state constitution might mean. In terms of remuneration, it's all subject to the control of the states. So, which means that if the state parliament decides that the remuneration of state judges be changed, they can do that. So it is very crucial, therefore, that you have to make a distinction as to whether or not a judge is a state judge or a federal judge. And that is also because, apart from a question of how they have been appointed, there is always a question of the kind of powers that these judges can actually exercise. And we're going to get into more detail into that when we go through this tutorial. So there was a point here by B. Even in an acting capacity, okay, federal courts cannot exercise state jurisdiction. That's right. But state courts can exercise federal general jurisdiction. That's correct. In certain cases, when, for example, it will involve a Commonwealth officer, or the case that might come before a state court pertains to a matter between the state and the Commonwealth, or it could be it can pertain to two citizens who belong to different states of Australia. Okay. Any other questions? And
yes, Manjo.
It's gonna make more sense as we dig deeper into this topic by going through the discussion questions. Yes, Janet.
I just want to clarify with you.
Yes.
The state courts, for example, the Supreme Court is a state court.
That's correct.
But it can also listen to or hear federal cases. Is that correct?
That's correct, yes.
And that's where there's a duality in my mind to the court system, in that the court may be a state Supreme Court, but under certain conditions, it is then vested with federal powers via the Constitution to be able to hear matters concerning federal issues, yes, or depending on the parties. Have I got that right?
Correct. You got that correctly. That's correct. But, and so that's what, and so we're just going to clarify, however, that even when a state Supreme Court becomes or acts as a federal court, because it is dealing with a federal matter at the state level, it is still not a Chapter 3 court, although it is exercising certain federal judicial powers.
And it has to exercise those because the chain of appeal then goes right up to the High Court.
That's correct. Yes, that's right. And so we will remember that there is what is known as an autochthonous expedient doctrine, which tells us that while state courts belong to the states, they're actually part of the integrated federal court system in Australia. So the state courts are creations of the state, but at the same time, as you correctly pointed out, Janet, they have a duality in terms of identity, because they also form part of the federal judicial system.
Thank you. That took me ages to clarify in my head.
Okay. Other questions? So we could probably begin. Okay. So that was helpful. Hang on. I'm just going to take note of those who actually asked those questions, because that would count for the class participate. And if you could later on, to those who actually asked important questions, just send me an email just in case I may have forgotten that you actually participated using the mic in tonight's tutorial. Okay, so we could probably begin. We're going to be going through 4 tutorial questions tonight, and these 4 tutorial questions should enable us to dig deeper into this topic. Okay, so question 1. Jim Freeman was arrested after images of child pornography were found in his computer. That was seized by the police. His computer had been seized and searched on the basis of a search warrant issued by a judge of the Federal Court of Australia under the New Security Measures Act, Commonwealth. He challenged the constitutionality of the act, arguing that in issuing the search warrant without giving him a right to a hearing, the judge breached the rules of natural justice and exercised a non-judicial power that was prescribed in the Boilermaker's case. Rule on the constitutionality of the act. Hang on, I'm just gonna close the window. I think it's a bit noisy even for me. Just give me a second. Okay, so can I have a volunteer?
Yeah, I'll have a go, Manjo. Peter Anderson.
Peter, yes, Peter, go ahead, please.
I guess, looking at it, the issues are whether the judge is allowed to issue a warrant, and if he's a federal court judge, is he acting within a Chapter 3 court scenario, and and whether or not he's allowed to, does he have to participate in procedural fairness or not? And I guess the first question could be answered by Hilton versus Wells, where it was deemed that judges are allowed to issue warrants. If you look at it in that term, he's performing a non-judicial function. So if he's a Chapter 3 court performing a non-judicial function, he must be acting persona designata, which, I think the case was Drake and the Immigration Department of Immigration and Ethnic Affairs.
Yes.
So if he's acting persona non grata, like you said earlier in the preamble, that it has to be with his consent, and it's not allowed to be incompatible with his role as a judge of a Chapter 3 court. But because he's acting with the term non-judicially, there's no requirement for him to follow procedural fairness.
Okay. So you've captured some of the legal issues there. So thank you about that. But I am not convinced that we've actually clearly identified the crucial legal issues. So definitely the question of whether or not that particular federal judge can issue a warrant is a valid question, but it does not really raise the important legal issue that is involved. What exactly is the legal issue that we're trying to address with this factual scenario?
Can I have a shot at that, Manjo?
Yeah, so it's crucial. So what you need to do is, especially in the legal memorandum, it is important that you do not come up with an answer by directly providing a response to the question. So don't just repeat the question like, can he issue a warrant? Can he disregard the rules of natural justice? If you answer those factual questions straight away, you're missing the point because you did not actually engage with the legal issue. So if the question is, can he issue a warrant? What exactly is the legal question there? Or if the question was, does he have to observe natural justice? Okay, that's a factual question. But what exactly is the legal issue? Because it is the legal issue that you need to address. Are you able to see the distinction or not? Because if you don't, you will have a problem with your legal memorandum. So the question is, can he issue a warrant? Yep, fine, that's the question. But what is the legal issue that needs to be addressed, that if you're able to identify that legal issue and identify the legal principles related to the legal issue, you can then quickly answer the factual question. In the same way, the legal issue is not, does he observe natural justice? No, that's a factual question. But what is the legal issue behind that question that needs to be identified, and then that you need to identify the legal principles in order for you to easily answer the factual question? Can you see the distinction? Because you need to be able to do that here as well as in the legal memorandum. So, for example, as B pointed out, is he acting in a judicial, is he exercising a judicial or non-judicial power? Now that is a legal issue. Now I am not yet saying if that's the correct legal issue, but that is the way you frame a legal issue. So in other words, you might say, the judge in issuing a warrant, is he exercising a judicial or non-judicial power? That is the legal issue. So let me repeat. The question is, can the federal judge issue a warrant? That's the factual question. But the legal issue is, can the federal judge, is the federal judge in issuing a warrant, is he exercising a judicial or non-judicial power? That is the legal issue. Why is that crucial? Because we know that if the federal judge is exercising a non-judicial power, then that is likely to be impermissible according to the Boilermaker's case, which says that a federal court or a federal judge should only be exercising judicial powers. Okay? Now, but on the other hand, assuming that this federal judge is actually exercising non-judicial powers, it leads us to that next legal issue. Are there instances when a federal judge can actually be permitted to exercise non-judicial powers? And that leads us to the next principle of the persona designata doctrine. Okay, did we see that? So, and so that is what B is pointing out here. B, I wish, well, obviously you've been, providing answers in the Moodle forum, so that's good. I was just saying that B, if you use your mic, then quickly you get points for engaging in the tutorials, because a lot of the things you write in the chat box are actually very, very important. So as B pointed out here, the legal issue is, can a Chapter 3 judge exercise a non-judicial power? So that's the way you would formulate the legal issue. So going back, I think somebody was trying to say something. Who was that?
It was me, Manjo, and you went through the first part of my answer already.
Okay, so what I'm doing now is actually to try to go a bit slow in dealing with this topic, because I could give you the answer, but you're not going to learn much, okay? In fact, the answers can easily be posted in Moodle, and the answers are actually just hidden. I could just tick a box, and it's going to be visible. But what I'm trying to do in this tutorial is to try to train you to analyze this in a legal way, so that when you're confronted with a factual scenario or case problem such as this, you then are able to provide an answer in a legal manner that actually addresses the legal issue. Okay, so that's why we're trying to go slow on this. To me, it's not so much about coming up with the correct answer. I think that's easy. What is crucial is how you arrive at that answer. Because it's one thing for you to come up with an answer, but the question is, what is your reasoning behind that answer, and how did you arrive at that answer? It is actually possible for a student to arrive at a correct answer, but actually the student misidentified the legal issue. So what is crucial is never, to me, it's not the conclusion, because we can always arrive at a conclusion even if we've misidentified what the legal issue is. What is crucial is being able to identify what the legal issue is. And that's why right now I'm trying to do this a bit more slowly. And also because I realize it's the midterm break anyway, so I don't think anyone will be, will be using the Zoom, this Zoom license later on. So I'm just gonna go slow. I mean, unless you want us to just zoom through the discussion question, that's also a possibility. But I'm hoping to spend a bit more time focusing on the IRAC format as well, and helping you think like lawyers, because we can have a way of assessing an answer by providing multiple choice questions, and then you'd say this is the correct answer, but it's not going to help you much. What needs to happen is for you to figure out how to articulate and identify what the legal issue is in a case problem such as this. So, are we happy with that? Because it's now 6:30, so we're quite slow. But as I said, I'm deliberately doing this because I'd like to help you do this correctly. Because otherwise, if you don't do this correctly, you're not going to come up with a good legal memorandum, because you're probably just going to go straight into answering the question without properly identifying what the legal issue is. So where are we? Okay. Any other comments? So thank you, Peter. Janet as well. Comments? Where are we now? So what exactly are the legal issues here? So we've identified one of the legal issues, and the legal issue we identified, I think, was that in issuing a warrant of arrest, is the federal judge exercising a judicial or non-judicial power? So you will notice that by asking that question, you need to be able to distinguish a judicial as opposed to a non-judicial power. So that's the legal issue. Then you're able to connect the legal issue to legal principles. And we have a definition of what a judicial power is as opposed to a judicial power by looking at the Hunter Parker case. Okay? Now, what is the next question that needs to be answered? So let's just get that out of the way. Is he exercising a judicial or non-judicial power? Let's answer that first.
Non-judicial.
Non-judicial. Okay, so it would seem here that the judge is exercising a non-judicial power. Why was that? Why is he exercising a non-judicial power, not a judicial power? Who was that who said it? I couldn't identify who said it. Why do you say that?
It was me.
Was that Peter?
Yeah.
Okay, Peter, why do you say that the federal judge is exercising a non-judicial power? Why?
Because issuing a warrant is not considered a judicial function.
Why not? Come on. So can you see why this is important? We're not dealing with legal principles here. So why is he not exercising a judicial power? Why is it a non-judicial power that he's exercising? I mean, you can say that he's, because the issuance of a warrant is a non-judicial function, but it doesn't really answer the question. So, I mean, why isn't the act of issuing a warrant a judicial function? Why?
Can I
Can I give it a try?
Who's first?
Oh, whoever. That's all right.
I mean, who was the lady there? Sorry. Huh?
Can you hear me, Manjo?
I could hear you. You need to identify yourself because I'm having a problem knowing who's speaking. Who's that?
Can you hear me, Manjo? It's Mary Ann.
Mary Ann, yes, good. I could hear you, Mary Ann. Go ahead.
Is it because there's no controversy yet? Like, there's nothing, you know, there's no controversy yet?
That's right.
Like, it's a hypothetical thing until they get trialed, like to go to trial?
Now, those are two different things. You were in the right direction when you said that there is no actual controversy. There is no actual controversy between the state or the subject or between subjects of the state. In fact, if you will notice, it's on the initiative of the judge himself in issuing the warrant.
Yeah.
So there isn't any actual controversy. It does not involve a matter. Therefore, what is involved is the exercise of a non-judicial power. So
that's right. Yeah.
Okay, so that's good. So we've dealt with that. So the question is, if the federal judge, so I'm just gonna write it. Are you able to see it on the screen as I type? So if the federal judge in this case, is exercising a non-judicial power, is that legally permissible? So that's the next legal question. Because we know, so you bring in the Boilermakers case, we know the rule. Federal courts, federal judges cannot exercise non-judicial power. So if that is the legal case, if that is the case that we know, according to Boilermakers, how then would it then be legal permissible for this federal judge to exercise a non-judicial power? That's the next legal question. What do you think? So we're bringing new legal principles in. What's the next step?
Well, they can do it. You know, judges can use their non-judicial powers, even when there's not a controversy, but only in certain circumstances. As long as it doesn't affect their duty as a judge or something like that, like their position.
Is that you, Marianne?
Yeah.
Is that you, Marianne?
Yeah, it is. Sorry. Okay. Yes.
I'd find that too broad.
Yes, it is. Hang on. Okay. Yeah.
You're there. But
what about Manjo, the Drake and Minister for Immigration case?
What about it?
Where the High Court said there's nothing in the Constitution which would preclude a judge of the High Court.
Yes.
Or any other court created by the Parliament under Chapter 3 of the Constitution from in its personal capacity from being appointed to an office involving the performance of administrative or executive functions, including functions which are quasi-judicial in their nature, does not involve an impermissible attempt to confer upon a Chapter 3 court functions which are hypothetical to the exercise of judicial power.
Yes.
Something like that.
That's right. That's a correct case that you've cited, and you've articulated the correct legal principle. Okay, so as you said, according to Drake versus Minister of Immigration, under the Procedural doctrine, it is permissible for a federal judge. So you never speak you don't speak of a judge. You have to be clear that the federal judge is the judge. So it is permissible under the persona designated doctrine articulated in Drake versus Minister of Immigration. It's permissible for a federal judge to exercise non-judicial powers in his personal capacity with his consent if the exercise of non-judicial powers would be compatible with his judicial functions, both because one, he acts independently, and two, because he does not bring the judicial system into disrepute by being an instrument or tool of the executive or the legislature, or by becoming or by acting in a way that brings questions to his integrity.
That's the end of it. Yeah, right. Cool. Thanks.
Very good. So that was very good, Mary Ann. Now, there is a second aspect to this, and the second aspect was this judge, in not allowing a person to be heard, he seems to have violated the requirement of natural justice. Now, how do you deal with that? So can a federal judge disregard the rules of natural justice? That is another legal principle. So we actually have three legal issues here. Okay. So I'm just gonna, okay. So I'm just gonna separate the rest. So these are the three legal issues here. The third legal issue is, can a federal judge disregard the rules of natural justice? That seems to be pertinent. What do you think?
Hi, this is B.
B, yes.
I think it's perfectly fine when he's not acting in a judicial capacity. There is actually no requirement the rules of natural justice be applied.
Perfect.
In fact, his decision is not appealable because it's not a judicial decision.
Well done. So that's perfect, B. Thank you. Okay, so we're good. We could move on. Questions? No? Okay, we'll move on. So that was good. Thank you, B. And thank you to Mary Ann and the rest. Okay, question 2. Olsen Magpie was arrested after images showing bestiality were found in his computer that was seized by the police. His computer had been seized and searched on the basis of a search warrant issued by a judge of the State Supreme Court of New South Wales under the New Security Measures Act, New South Wales. He challenged the constitutionality of the act, arguing that in issuing the search warrant without giving him a right to a hearing, the judge breached the rules of natural justice and exercised a non-judicial power that was proscribed in the Boilermakers case. Rule on the constitutionality of the act. Okay, can I have a volunteer? Let's begin by identifying the legal issue or the legal issues. What are the legal issues here? Before we start answering the question, before we come up with a conclusion, the most important thing as a basic is correctly identify the legal issues or all the legal issues. So what are the legal issues here? Okay, volunteers.
Manjo, I haven't done the answer, but is it in relation to if the act?
Sorry. I have a problem with my Zoom. I can't easily see who's speaking. So sorry about that. So Mary Ann again. Sorry. And I can't quickly identify the voices yet. I will at some point. Okay. I actually thought it was you, Mary Ann, but I couldn't be sure. Okay, Mary Ann, go ahead.
I haven't done the answer, Manjo, but is it in regards to determining whether the act is constitutional? Like, is it state or federal?
What about?
No, it's not. No, I've lost it. Sorry, Manjo. Okay. Don't worry.
That's withdrawing. Constitutional. That's not a legal issue. That's
no.
The broad. But what's the legal issue here?
Can I try?
Who would that be?
That's justice.
Justice. Yes, go ahead, please. Justice.
I think we can ask a similar question like we asked in question 1, which is a state Supreme Court judge exercising non-judicial or judicial powers in issuing a warrant of arrest?
is the state judge exercising okay, I'm just choosing it broadly, whether state judge, an ordinary state judge, or a state Supreme Court judge. So in general, is a state judge exercising non-judicial powers?
Yes.
Is that a legal issue? That's a question. Hang on, can you see the difference between, can you see the distinction there? When you ask, is the state judge exercising non-judicial powers? It allows you to answer you with a yes or no. It doesn't seem to be that helpful. If you were to rephrase it, how can you rephrase it in such a way that it brings in a legal issue or an important legal principle?
Maybe ask what powers is the state as a state judge exercising in issuing a warrant of arrest?
Okay, so you can ask. So the question you were asking is, can a state judge issue warrants of arrest?
Yeah.
That still seems to be a yes or no answer.
Manjo, it's Sarah.
Yeah.
Could you say what type of power is the state judge exercising in issuing a warrant of arrest?
What kind of power is the state judge exercising in issuing a warrant of arrest? What do the others think? Is that a
Manjo?
Is that a good way of identifying the legal issue? Yeah.
Is it okay? I go ahead.
Go ahead. Janet, I think, is that you, Janet?
Yes, it is.
Yes.
Yes. It's a state act and it's a state court. Therefore, I'd be looking at the separation of powers doctrine. Do they apply in this particular case? Because the state act in the state court, there is no separation of powers. There is parliamentary supremacy. I haven't framed that question very well, but I'd be looking at whether the separation of powers applies to that in a constitutional
That's
manner.
Better because you're bringing in a legal principle about the separation of powers, but it's just too broad. I don't know how to answer that. It's still
Manjo.
Yes.
Marianne again.
Yes.
A second attempt. Could we say what are the key characteristics of a state judge?
No.
No.
That's not a legal issue.
Okay.
So a legal issue, based on the facts, leads to a need for you to state the pertinent legal principles. So if you ask a question that leads to a yes or no answer, it's difficult to say that it leads to the statement of a legal principle. Any other attempt?
It's Vicky.
Vicky.
Yes, Vicky.
Yes, Vicky.
Would you not be asking that basic, a question again, is it a judicial or a non-judicial power?
Okay, so let's do it there. So is the state judge what was he doing? Issuing a search warrant, exercising a judicial or non-judicial power? Hang on. So have you asked that question before? Is the judge... Okay, so we had this earlier. Is the state judge exercising non-judicial powers? That's yes or no. But this one, if you'll notice, it's a different... The question, the issue identified by Mary Ann is different because her question was, is the state judge... I'll try to remove this. It won't come out. But for Mary Ann, the way she articulated the question was, is the state judge in issuing a search warrant exercising a judicial or non-judicial power? So that is a different question because you are forced to try to define what a judicial or a non-judicial power is. Can you see the distinction there? Okay. Now, so we will define this. So because we know what the Huddard-Parker case says, we know that he is exercising a non-judicial power. So the point, therefore, is if is it then permissible for a state judge to exercise non-judicial powers in issuing a warrant of arrest, or a search warrant rather. Okay, so that's the legal issue. Is it permissible? Because we said the answer here, the answer to this, to the first question was, is the state judge in issuing a search warrant exercising a non-judicial power or a judicial power? The answer was, he is exercising a non-judicial power. The next question is, if he is then exercising a non-judicial power, is it permissible for that state judge to exercise non-judicial powers? That's the next question. What do you think? How do we answer?
Yes. Janet, yes.
I'd like to hear from Scott, then I'll go back to Janet. Scott, yes.
Manjo, I would say that it is permissible for a state judge to exercise non-judicial powers in issuing a search warrant. Hilton and Wells,
yes,
where the High Court determined that the issuance of warrants by judges of the federal court, albeit federal court, authorising the tapping and recording of phones related to a criminal investigation was non-judicial and valid as an exercise by the judges. So I would say that it is federal. However, that would be binding upon state courts, would it not?
Yeah. So you see, that's exactly the reason why I said I don't want to put too much weight on the conclusion, because actually, Scott, you had the correct conclusion, but you actually had the wrong reasoning. The conclusion was correct, but the reasoning was wrong. The citation of legal principles was also wrong. Can somebody explain why that seems to be my view? The conclusion of Scott was correct. This is permissible. It is permissible. But I said that the answer, the reasoning, and the cited legal principles are actually incorrect. Why am I saying that?
It's Vicky.
Vicky, yes.
Because there's no separation of powers at the state level, and therefore the courts can be vested with non-judicial powers.
See, that's exactly the point. We're not dealing here with a federal judge. We're dealing here with a state judge, which means, therefore, that the Boilermaker's case is inapplicable. Okay? So this is what is known as a red herring. The Boilermaker's case has no application to the case facts because the Boilermaker's case refers to the impermissibility of the exercise of non-judicial powers by federal courts or by federal judges. The case facts, however, as pointed out by Vicky, involve a state judge. And as pointed out correctly by Vicky, in states there is no separation of powers. It is permissible for state judges actually to be vested with non-judicial powers. Okay, did we get that? Now, B here is raising the point that cable principle must be observed. Okay, so B, would you like to expound on that, or can somebody pick up on what B here has flagged? What is it about the cable principle here? What is it about the cable principle?
Marianne?
Yes, Marianne.
Is it because there are limits to the state, like state parliaments? You know, we inherited the UK law. And so when it got federated, state parliaments kept that separation of powers. And then in the cable case, it sort of says there are limits to the state parliamentary power, but more than that, like the High Court said that the states must each maintain courts, or at least a court for the exercise of judicial power of the Commonwealth.
Very
so
good.
Even in states, there must be a court which must exercise judicial power of the Commonwealth.
Very good.
That is because what is provided in the Constitution that there are state superior courts.
Very good.
2, state parliaments cannot legislate to confer power on state courts which are repugnant to or incompatible with the exercise of the judicial power of the Commonwealth.
Very good. Connect it to the facts now and connect it to the cable principle. You're there. Very good. Connect it to the cable principle and the case facts. So,
okay.
So that.
So say, yeah. So,
come on. Very close. So that was a distinction. I'd like to hear a high distinction answer this time. That was really good.
Okay. Okay. Sorry, no, too much pressure on Manjo. I can't do it.
Okay, can somebody pick up from what Mary Ann was saying? That was a distinction answer.
Okay, thanks.
I want a high distinction answer. There was something that's missing there. We haven't connected the case facts. We haven't connected the cable principle to what Mary Ann was saying. So she cited the correct legal principles, yes, but they have not been connected yet to the case facts or to the cable principle. So what's missing here? How do we connect that?
It's Vicky.
Vicky, yes.
Does that only apply when judicial powers are being exercised? So in this case, it wouldn't be applicable because you're exercising a non-judicial power?
No. But what Mary Ann was saying is that even if there is no separation of powers at the level of states, and so therefore it's permissible for state judges to be exercising non-judicial powers, still, there are certain things that state judges cannot do or cannot be permitted to do. So having said that, connect that to the case facts and to the cable principle.
And Manjo, it's Mary Ann again. Is it in regards to natural justice?
Okay, go on.
So in other words, like if state courts end up not following the rules of natural justice or they become tools or instruments of the executive or legislature,
the problem there, Mary Ann, is that it begs the question, are state judges actually required to observe natural justice in the first place?
Yes.
So that's the problem there.
Are they? Yeah, you tell me.
Hang on, from B. Hold on, from B, is there independence of action on the part of the judge? Okay, yeah, so it's getting there. Well, anyway, because we're running out of time. The point there, based on what B, who was that?
Yeah, sorry, Manjo. Scott Wellburn. I was just wondering if, because of the cable principle, we're saying that the state courts, state parliaments can't legislate in a way that undermines the role of state courts as repositories of federal judicial power, even though they're not applying federal judicial power in this instance.
Yes.
They will have to have that persona. They must be perceived to be independent of the legislature and the executive.
Yes, that's the connection I was looking for. Well done. So what we're saying here is that even if at the state level there is no separation of powers, and therefore, because there is no separation of powers, it is permissible for a state parliament to vest non-judicial powers on a state judge. So that's permissible. However, because judges and state courts are actually part of an integrated Australian federal system, judicial system, under the autochthonous expedient doctrine, then there is a requirement that even when state judges are exercising non-judicial powers, they must do so in a way where they can still maintain their independence or act in a way that does not bring disrepute to the entire federal judicial system, because state judges nonetheless still belong to the integrated federal judicial system. That's according to the cable principle. So can you see the distinction there?
Yeah.
Okay, very good. So we can leave that. Now, it's almost 7. Do you want to continue or do we end at 7? We were quite slow. What's the pleasure of the group?
I'm happy to continue.
Okay, so we could probably go a bit faster. So we'll continue. If you need to drop out, just drop out. I would understand. I'm willing to hang on anyway because, well, I'm not doing a lot. So we go to discussion question 3. Alex Cornwall challenged a ruling of the Australian Board of Accountants created under the Australian Board of Accountants Act, Commonwealth, which revoked his registration and license as a chartered accountant of Australia. The Act authorized the members of the ABA to evaluate and review on ABA's own initiative the competence and ability of chartered accountants registered and licensed under the Act to carry out or perform adequately and properly their functions under the Act. Cornwall argued that the ABA, in exercising federal judicial powers, violated Chapter 3 of the Australian Constitution. Rule on the legal challenge. Okay, what's the legal issue? So the legal issue cannot be a mere restatement of the question. Okay, what's the legal issue? Volunteers? Okay, good. So from B, is the ABA a Chapter 3 court? That's a good question. If that's the kind of question you ask, you can't answer, oh, well, you could say it's a yes or no, but you need to define what a Chapter 3 court is. So is the ABA in exercising, given the powers that are there, given its powers, is the ABA given its powers a Chapter 3 court? Let's begin with that. What do you think? What is a Chapter 3 court? Can somebody try to answer? Can we begin by answering that legal issue there? Is the ABA given its powers under the Act a Chapter 3 court? Volunteers?
Vicky.
Yes.
Okay, so you need to consider, pursuant to Section 75 of the Constitution, whether the court is actually exercising judicial power in relation to a matter or a controversy, and whether that court or tribunal is able to give a final binding or conclusive decision.
Mm-hmm.
Therefore, I would say that it's not a Chapter 3 court.
Okay, so your answer is
sure.
not, because? What was it again?
Because it doesn't meet the criteria of being a Chapter 3 court, in that it's
Because?
Is it actual controversy? And are they able to give
controversy? According to you, yes. What else?
Is it a final binding decision? I'm not sure whether that's the case or not. But yeah, mainly is it their actual controversy, or is it because the board made a decision in the first place, so it was instigated by them?
Can I come in with something, please?
Yeah.
Shannon?
Please do.
The first element, it seemed to be met, but it was only after there was intervention by the ABA that there seemed to be a controversy. Prior to that, there wasn't one that was being investigated.
Okay. So there is no actual controversy, there is no matter, therefore, it is not exercising judicial powers. So what we're doing here is we're trying to look at some of the powers. We're trying to identify what the powers are, because by looking at the powers, you're then able to determine whether or not this is a court. Okay? So you're trying to determine, is this a Chapter 3 court? And the way you're doing that is by looking at its powers. You can also look at it from the viewpoint of how it was constituted. Okay, but in this case, what we're trying to do is to try to determine whether or not this is a Chapter 3 court on the basis of its powers. Okay, so there has been...
on the basis of its powers, it's got a public policy function, which is generally not invested in a Chapter 3 court, but is vested in a tribunal.
Very good.
For example.
Yes. Where do we get that about a public policy function? Where's that? Is it there? Janet?
It doesn't say so per se. I've interpreted it from the fact of it's got a regulatory type of role.
Where does it come in? Is it there?
To evaluate and review. That's a regulatory investigative role, which is not the role of a Chapter 3 court.
Very good. Okay, what else? There's from Vicky. It uses discretion. Yes. What else? What else?
The language is also very broad, whereas...
Which one? Which language is broad?
I beg your pardon. The language to carry out or perform adequately and properly. That's very broad. It's not specific and it's really not measurable, except subjectively.
Okay, that's good, but it's not so much that it's broad. What's the problem with that kind of criteria for decision making? It's not that it's broad. It means
it's not precise.
No, it's not that. What is it?
Not relevant here. Also.
Hold on. Just in relation to this point that Janet was raising, that it seems that under the Act, this board makes a decision, carries out or performs its functions adequately and properly. It's not the fact that it's broad. In fact, it's very possible for the legislation to define what is adequate and what is proper. So it can be very specific. And in fact, there is a legal meaning to what is adequate and what is proper. That is accepted already. We know what is adequate and what is proper. But what's the point? According to B, it's because this is actually not, when you say this, it does not provide it's not based on, it does not provide a legal, how do you call that? A legal criterion for the decision. That's the reason. So if it is a court can only decide according to the law, according to the legality of the Act or the legality of the law. A court will not come up with a decision on the basis of whether or not the law is adequate or it is proper. That is, it's not so much that these criteria are imprecise or they're too broad. It is that they are not legal criteria. So judges can only adjudicate on the basis. Chapter 3 judges can only adjudicate on the basis of the law, on the basis of legal questions, not as to whether or not something is adequate or proper. Okay, from Scott, adjudicate without technicalities or legal form. Is it there? Well, that would have been it. So in general, therefore, we will observe that this specific board seems to be acting in the following manner. It doesn't deal with actual controversies. In fact, it initiates proceedings on its own. It does not seem to make a binding decision. Is it there? Fourth, it seems to perform a regulatory function or a public policy function. It seems to be there. It seems to be using discretion, which is not a legal criterion. It seems to carry out or perform its functions on the basis of what is adequate or proper, which are not legal criteria. So on the basis of these elements, of these dimensions, it is difficult to say, or it is difficult to characterize the board as a Chapter 3 court. And because it is not a Chapter 3 court, obviously, it can perform non-judicial functions. Did we get that? Did we get that? Now, on the other hand, what if this specific law, so I'm just gonna, I don't know if it relates to the last question, but let me just change the case facts a bit. What if this specific act also said that the board can make a final and binding decision, a final, conclusive, and binding decision? So in addition to all these dimensions that are there, what if the act also empowered the board to make final conclusive and binding decisions.
Marianne, Manjo, the judicial system wouldn't allow it. Like, they can't do it. They can't make a final and binding decision because they're not a Chapter 3 court.
Okay, so that's one way of looking at it. But my question was, what if the Act also empowered the board to make final, conclusive, and binding decisions? So in addition to everything that's there in the case facts, what if there was a provision in the Act which gave the board the power to make binding, conclusive decisions? What then?
Would it be invalid?
Go on. Why?
Because it'd be unconstitutional.
Why?
Unless they were created like as a Chapter 3 court. Because only Chapter 3 court, they're not a court, so they can't make a legal, like a binding decision.
Okay. So,
hang on. Yeah.
So what if the law actually empowered it to make valid, conclusive, and binding decisions? So in other words, it seems like, could it be that the Commonwealth Parliament actually was thinking that this should be a Chapter 3 court?
Yeah, they can't.
What do you mean they can't? The federal parliament can't create a Chapter 3 court that it calls a board?
They can.
Yeah.
They can create a chapter. Well, the Chapter 3 courts are created by the Constitution. So.
No, it's not created by the Constitution. It's created by Parliament according to the Constitution. The only Chapter 3 court created by the Constitution is the High Court. So what could have happened is that the federal parliament creates a Chapter 3 court according to the Constitution. So in this case, we're looking at a situation where the federal parliament seems to be creating a Chapter 3 court with these powers. So you've got, everything else in addition. It's what if, again, I'm changing the facts. What if one of the powers of the board was to make valid and binding decisions, conclusive binding decisions? So what then?
Manjo, this would not be possible because that would contravene. This is actually the case of the Boilermakers case.
Okay, hang on. B, you're getting there. I'm just going to correct you a bit. Don't use the word possible. Okay, because possible to do.
Okay, all right.
Permissible or not permissible, that type of.
It would actually be not permissible because this is actually the facts of the Boilermaker case. Where the arbitration court was given both judicial and non-judicial functions. And in appealing the case, the High Court actually said that a federal court cannot perform both judicial and non-judicial functions, and therefore the court was not a validly constituted court.
Perfect. Perfect. Well done. That's perfect. That's high distinction. Well done. You got it there. Okay, with a perfect citation of the Boilermakers case. So don't be deceived by the nomenclature of the tribunal, because it can be a board, it can be whatever. And in fact, if it was constituted as a Chapter 3 court with the powers of a Chapter 3 court, then that law must make sure that it doesn't integrate both judicial and non-judicial functions, because that won't be permissible. So in this case, if in addition to what is in that act, had there been another provision where this specific board had been given the power to make binding and authoritative decisions, then that would have made it a Chapter 3 court. And because it seems to have been a Chapter 3 court, it would have been impermissible for that Chapter 3 court to be then performing non-judicial powers, to be exercising non-judicial powers such as initiating a proceeding on its own, undertaking regulatory functions, or you're using discretion and so on. Okay, clear enough?
Yeah, that's good.
Very good. So let's go to the final question. ABCD Enterprises went to the High Court to challenge the constitutionality of the Workplace Accident and Safety Board Act, Commonwealth, on the ground that it vested the Act vested judicial powers on the board in violation of Chapter 3 of the Australian Constitution. So the Workplace Accident and Safety Board had fined ABCD Enterprises the sum of $25,000 after an investigation and a finding that the company failed to properly observe work and safety rules under the Act. Under the Act, an employer aggrieved by a decision of the board may appeal to a court, rule on the legal challenge. Okay. What do you think? What is the legal issue? Can I get volunteers? What's the legal issue? 7:13. So we can finish this. Volunteers? How many are there? Okay, somebody.
I'll have a go, Manjo. It's probably wrong, but I'll give it a shot. Scott.
Scott. Okay, Scott. Yes.
Yep. So would the legal issue be that issuing that fine is ABC, the enterprises exercising judicial power?
Mm-hmm. Okay. Is the board, that specific board, is the board exercising judicial powers? Okay, very good. That's good. So that's good because you're connecting the question of the issuance of fine with a question of judicial powers. But okay, at a broader level, because you're only looking at the dimension about fine. So that's good. That's correct. That's part of the legal issue. But at a broader level, what are the other powers that are being exercised by this board? So that, at a broader level, what should the question be? At a broader level, instead of focusing on an aspect of the
quasi-judicial powers?
Huh?
Would it be quasi-judicial powers?
What's the question there? That's a phrase.
Well, it'd be the similar thing in issuing the fine. Is the board exercising quasi-judicial powers?
Okay. Yeah. But my point there was you're only focusing on a dimension of the facts. You're only focusing on the issuance of the fine. Isn't there anything else that is relevant to the question of whether or not the board is exercising judicial or non-judicial powers? What else? What is in the Act about the powers of the board which are relevant to a determination of whether or not the board is exercising judicial powers or non-judicial powers? So in other words, I'm asking you to raise the issue that has been initially identified to a broader...
Okay. Yep, so that would be, well, can Parliament vest judicial powers on the board, I suppose? Like, yeah, I'm sort of stuck out of word.
So, hang on, I'm just going to write that down because I'm intrigued by that answer. So can the federal Parliament vest judicial powers on the board? Okay. My problem with that formulation of the issue is it begs the question. Can the federal Parliament vest judicial powers on the board? The question is, what kind of board is it in the first place? Is it a Chapter 3 court or not? So it leads us to that question. Before we can answer that question, we really need to define what is this board? Is this board a Chapter 3 court?
Yeah, that's a Chapter 3
that's
court.
the basic question. Right? Don't you think?
Yeah, so we go, is this board a Chapter 3 court? And then conversely, can federal Parliament vest judicial powers in a non-Chapter 3 court?
Yeah, so that's the legal issue. Very good. Now, so if we say that given the Act, given the provisions of the Act, the legal issue is this board a Chapter 3 court? What is the answer there?
No.
No, not a Chapter 3 court. not a Chapter 3 court. Why? Why? Go on. Go on. Why do you think that it's not? Sorry, I couldn't hear you well. What was it?
I suppose it doesn't comply with the Constitution in Chapter 3. The makeup is not. It's a board. It's not defined as a court. There's no. It doesn't. You know, it's not applying law as such, like the High Court. It doesn't.
The problem there is you're assuming certain facts which are not in the case. Just because they're missing doesn't mean, you know, it's there or it's not there. So try to come up with an answer on the basis of what's there, on the basis of the case facts, because it's a law that has been created. We will assume that there were probably provisions on the way that the board was constituted, but it's not in the case facts. But we cannot assume either that the constitution, that the way that the board members were appointed wasn't according to Chapter 3. For all we know, it could have been according to Chapter 3, but we don't know that. So given the facts that are there, let's focus on the facts. On the basis of the facts here.
Would it be because it's adjudicating on its own initiative?
Okay, so that's where we go. So you're saying that it is not a Chapter 3 court because it seems to be, it is adjudicating
on its own initiative.
What do we mean by that?
Well, it's conducted the investigation. The board has developed the evidence, and the board's made a determination and then issued the subsequent fine.
Okay. Very good. So what we're saying is that there seems to be no actual controversy. There is no controversy here, right? So it's not dealing with the matter because it seems to be dealing with it on its own initiative. There is no actual controversy or a matter. So you're saying because of that, this can't be a Chapter 3 court. Okay, so fair enough. What else? What else? So from Janet, there was no existing matter. The issue arose after an investigation. So it seems to be, it undertakes an investigation. Again, related to that first point, it undertakes an investigation, which means there is no matter. Again, no matter. Okay. In open and closed, in quotes. Okay. What else? What else is there in the case facts?
I think it's got something to do with the appeal. I mean, I seem to find that sentence a bit puzzling because if it wasn't a Chapter 3 court, then it's not a binding decision, and what it seems, redundant that they should write that there is a right of appeal.
So what does it tell us? What does it flag for us? If there is a provision which says that an employer aggrieved by a decision may appeal to a court. What does it tell us? If it's able to be appealed to a court.
Is that saying that it doesn't regard itself as a Chapter 3 court?
What? As a consequence, if
it's not binding, is it because it's not binding?
Yeah.
And they can be biased or unfair, like the judges can't.
So what it tells us, what it signifies, is that if its decision can be appealed, it would seem that the decision is not binding. So as you correctly pointed out, which means therefore if it is not binding, therefore it is not consistent with the powers of a Chapter 3 court. That's what we're saying, right? That's the argument. Okay. I kind of heard Sarah saying something. Sarah, did you want to say something?
I was just about to say about the non-binding and not being conclusive, but that was covered. That was all.
Not binding and not conclusive. Therefore, it's probably not a Chapter 3 court. Okay, what else? How about the fact that it can issue a fine? How about the matter of issuance of fine? Isn't that something that only courts can do? What do you think?
Doesn't that mean that therefore it's exercising a judicial power?
Mm-hmm. Okay. The question really is that the power to issue a fine, is that power judicial or non-judicial? Or differently stated, is it only courts that can issue fines? So in other words, is the power to issue fines exclusively a power that belongs to Chapter 3 courts?
Police issue fines.
Huh?
Police, like executive, issue fines too.
That's right. That's right. So according to B and Justice, in fact, administrative bodies and regulatory agencies can issue fines. So the fact alone that this body or this board is able to issue fines does not demonstrate that it is a Chapter 3 court, because a non-Chapter 3 court, an executive body, can issue fines. So it's not determinative. The power to issue fines is not determinative of the character or the nature of this board. Okay? So that's not material in that sense. What else are we missing here? Fail to properly observe. What about that? Fail to properly observe work and safety rules. In other words, in terms of arriving at a decision, this board seeks to determine whether a company has failed to properly observe work and safety rules. What can you say about that kind of provision or that kind of power?
It's like discretionary, sort of like, you know, they are investigating. They're, it's not really what a court does. I don't know.
Mm-hmm. Well, why would that be discretionary? It doesn't seem to be discretionary. The question is, you know, does it observe work and safety rules properly? It didn't say that the board has the discretion to determine whether work and safety rules have been observed. There is a standard by which it determines whether or not work and safety rules have been observed. The standard used is properly. So it's not according to discretion.
Okay.
So would it be, sorry, Manjo, is it again where it's adjudicating using broad standards?
It's not about broad standards. What is it? It's about standards. But what is it about standards?
Manjo, is it in relation to like what citizens can and can't do?
It's not providing a legal
policy.
What is the
legal criterion?
What criterion or standard does it apply to determine whether an act or a law is valid? What is the criterion? What's the standard?
Is it Scott, Robin here again. Is it because they're deciding on the basis of policy?
Yeah.
As Parliament's made the policy to, you know, observe the work and safety rules, and then they're making the decision on the basis of that policy.
I'm not sure if it's there. I can't see it in the facts. We can assume it might be there, but I don't think it's there. So we're assuming a fact that does not exist. What's the more relevant point here? What standard do Chapter 3 courts use for the purpose of determining whether an act is constitutional or not? What's the standard? We discussed this earlier.
This is, so Manjo, so this would be on the balance of probabilities, whereas the Chapter 3 court is...
it's actually about the standard always being legal. So as far as courts are concerned, they can only determine the lawfulness or legality of an act or a law. That's the only legal standard they can use. In this case, the standard that is being used is proper, which is not a legal standard. And so therefore, on the basis of all these dimensions, it can initiate an investigation on its own, so there is no actual controversy. It is not for parties that come before it to apply to, because there is an actual controversy. The decisions of this board is subject to appeal, therefore its decisions are not binding and not conclusive. And because the standard by which a decision is made is whether it falls on the question of proper, I mean, whether or not it's proper, which is not a legal standard, therefore we can assume, we can conclude that this board has been vested with non-judicial powers, and therefore it is not a Chapter 3 court. And because it is not a Chapter 3 court, it is permissible. This is an act that is constitutional, and the powers of that board are constitutional because it is not performing judicial powers. Okay, so legal criterion according to Janet. That's right, legal standard or legal criterion. Okay, so that's it. That's the last question. Do you happen to have any questions, anything you'd like to clarify before we end tonight's session?
Manjo, I know this might be next week's question, but I'm just wondering about this special commission. Should we get very hung up about the special commission? It's just a body, and we just treat it like some body, like, you know, this board or tribunal or.
You actually mean should be hung up by the
definition. What is the definition of?
Should we get hung up by the terminology of commission?
Yes. Yes.
Nomenclature. The answer is no.
Yeah, because you know, a royal commission has got a special meaning, and certain things. A commission, I don't know what it is.
That's right. So don't focus on the nomenclature, although this is really part of the assessment, okay? But because a student already asked me this, I posted it in Moodle. Don't get hung up on the nomenclature, because that's exactly meant to throw you off track. Don't look, because it can be called a board, it can be called a commission, it can be called anything. It could be called an agency. That's not determinative of whether or not it's a Chapter 3 court. What you need to examine would be the powers that it is exercising. You're also looking at the way that it was constituted. Those would be crucial. You'd also have to look at the remuneration, for example. You'd look at how a member might be appointed or removed. You might also look at the tenure of the members of a particular body or agency. Yeah, so that would be the way to look at it. Don't get hung up by the nomenclature. So that's a good question there. Okay, anything else? So, but we're gonna take that up, I think. We're gonna take that up next week in the special tutorial about the assessments. Although I'd like to tell you in advance that I can't really provide the answers. To an extent, I'll provide some guidance, but only to a point, because the rest of it would be something that you have to try to think about on your own. Okay, anything else?
Could I ask, Manjo?
Yes.
In regard to the assessment,
yeah.
Is there, in your opinion, one definitive answer to each of the issues posed?
My general answer would be yes. Generally, the answer is yes, but I'd be willing to see a different answer, which means it all depends ultimately on the way you argue your answer. Because the way you present an answer, the way you present your issues, the way you actually present the principles, it actually leads to an argument. So on the basis of your formulation of the legal issues, on the basis of the legal principles that you cite, and then which you then apply to the case facts, you're actually presenting an argument which leads to the conclusion. So if you've presented it in such a way that, you know, it all depends on the way you argue. It's often not that straightforward. It could be, but not necessarily. So it's possible, it's actually possible for there to be a different answer. And that's why sometimes you see that judges having dissenting opinions. They differ because they're focusing on a dimension of a case fact. So that's possible. But as I said, in general, I would think that there is one single answer, but I'd be open to seeing a different answer, but that will depend on the way you argue your case. Okay, anything else?
Manjo, last year, during administrative law, you actually gave us some examples of constitutional law legal memorandums.
Yes.
So we use the sort of format that is there.
Yes, they're actually in Moodle now. I've provided exemplars of legal memorandums that were submitted by constitutional law students. So as far as the format is concerned, there is no standard format. What you just have to make sure is that it appears like a legal memorandum. There are different ways of presenting a legal memorandum. And you can have a look at all the examples that are there, which are now in Moodle. Okay, anything else? So we're good. Okay, so good. So I'll see you next week, and thanks for being here tonight, even if it's your midterm break. And I'll see you again next week. We're going to cover week 6, the week 6 topic, as well as having a special tutorial of the legal memorandum. Thanks, everyone, and I'll see you next week. Good night. Bye.